Why the matter of Nchifor case is a problem. On June 24, 2022, the Board of Immigration Appeals released a decision, matter of Augustine Nchifor, the respondent. In this case, the court held that a respondent who raises an objection to a missing time or place information in a notice to appear for the first time in a motion to reopen has forfeited that objection. So let me break this down. There's been a lot of litigation, starting with Pereira in the Supreme Court of the United States, regarding the notice to appear being defective. So a notice to appear is basically the charging document in immigration cases, and it specifies the allegations against a respondent and the charges against them, making them removable. And on the bottom of the notice to appear, the time, date, and place of the hearing are supposed to be there. Now, there's been a lot of litigation around this that if it doesn't have that information, it's defective. And there's basically, at this point, with all of the litigation, we've come to the point where it being defective is relevant to the stop time rule. The stop time rule is about cancellation of removal and accruing the amount of time necessary to apply for cancellation of removal, usually 10 years for someone who is not a lawful permanent resident and 7 for someone who is a permanent resident. And so this is really important because people who had a defective NTA didn't have any other form of relief were able to then apply for cancellation of removal based on the stop time rule with a defective NTA. And the rule is with stop time is that if you are basically, you encounter immigration or you get put into proceedings, that stops the time counting towards the number of years that you need to be eligible for cancellation of removal. All right, got it. So now with matter of Nchifor, when it says that a respondent, an immigrant, a non-citizen, who is objecting to the missing information, saying that it's defective, the NTA is defective. And the first time that they're saying that is when they're trying to reopen their case. So say they have a removal of order of removal, and they're trying to reopen their case to apply for cancellation of removal. This is something that I was doing a lot. I know other attorneys were doing it too. And the real problem here is that matter of Nchifor is saying you can't do this anymore. And so this is going to have a really negative impact. So even though in matter of Nchifor, the case was ultimately remanded for other reasons, so it was a win for this respondent, it's a loss for people, a loss for those fighting the stop time rule, fighting for cancellation of removal based on defective NTAs. So this is why I'm concerned about this case. My name is Melanie Shapiro. I'm an immigration attorney in Massachusetts. Subscribe to my channel on YouTube. Follow me on Facebook, Twitter, TikTok, and YouTube, and Instagram. Thanks for tuning in. I'll provide more updates as they come in.